Much, Ben, and let me just echo the good morning, good afternoon, and good evening to everyone from wherever you are joining us. And welcome to our event on Title 42 and international law. As Ben mentioned, my name is Melissa Stewart. I'm a research fellow and adjunct professor of law at Georgetown Law and the co-chair of the Migration Law Interest Group at the American Society of International Law. I just want to start by thanking everyone at ASIL. Thank you, Ben, and everyone at Tiller House for making this event happen. As a reminder to our panelists and to our audience members, the panel today is being recorded and will be available on ASIL's website and their YouTube channel later today. As Ben mentioned, this event was organized by the Migration Law Interest Group and the International Refugee Law Interest Group. So I'd like to thank my collaborators on this event, Ian Kissel and Shana Tabak, for their collaboration and the support in organizing this important conversation. I'd also like to thank the Human Rights Interest Group, who co-sponsored this event with us. We are privileged to welcome today a distinguished group of panelists to talk with us about Title 42 and international law. We're joined today by Professor Ona Hathaway, who is the Gerald C. and Berners Latrobe Smith Professor of International Law at Yale Law School. She's a leading expert in international law and the author of a forthcoming article in the Cornell Journal of International Law on COVID-19 and international law. We're also joined today by Dr. Louise Ivers. She's a professor of global health and social medicine at Harvard Medical School, as well as the executive director of the Massachusetts General Hospital Center for Global Health. She's also special advisor to Partners in Health, a nonprofit organization she has worked with for decades to expand access to healthcare, particularly in Haiti. We're also joined today by Gerline Joseph. She's the president of the Haitian Bridge Alliance and the 2021 recipient of the Robert F. Kennedy Human Rights Award for her work in advocacy on behalf of migrants at the U.S.-Mexico border. Finally, we're joined by Lee Gallant, the deputy director of the Immigrants' Rights Project at the ACLU and the lead counsel on federal lawsuits that are challenging Title 42 in federal court. So just for some background on this policy, Title 42 is a policy that was implemented under Section 265 of the 1944 Public Health and Service Act. The act authorizes, and I quote, the director of the Centers for Disease Control and Prevention to suspend the right to introduce persons into the United States when the director determines that the existence of a quarantinable communicable disease in a foreign country or place creates a serious danger of the introduction of such disease into the United States, and the danger is so increased by the introduction of persons from the foreign country or place that a temporary suspension of the right of such introduction is necessary to protect the public health. The order under this act was initially issued in March 20th of 2022 and has subsequently been extended and amended. While unaccompanied minors are exempted from the order, it still applies to non-citizens migrating through Canada and Mexico into the United States. On Friday, as many of you may have seen, there was news reported of congressional testimony from October 2021 recently released that included some excerpts of testimony by Dr. Ann Schuchat. She was a former principal deputy director of the CDC, in which she testified that at the time that Title 42 was first implemented, that the facts on the ground didn't call for its implementation and that it wasn't based on a public health assessment at the time. Dr. Fauci has not publicly commented, but when asked about the policy, but said that expelling migrants is not the solution to the pandemic. Under the policy, people apprehended at the southern border and at our border with Canada are expelled to their country of last transit or their country of origin. Since March 2020, migrants have been expelled pursuant to this policy more than 1 million times. The UN High Commissioner for Refugees has called on the United States to end these restrictions to asylum and seekers and expulsions taking place pursuant to Title 42, noting the obligations under the Refugee Convention and UNHCR's position that protecting public health and the right to asylum are fully compatible. Now, particular concerns have been raised regarding Haitian migrants that have been expelled en masse pursuant to this policy. Effective in August of this year, the Department of Homeland Security designated Haiti for temporary protected status that allows Haitian nationals and stateless persons whose last habitual residence was in Haiti and who have been residing in the U.S. as of July 29, 2021, to remain in the United States until February of 2023. And the reasons given for this designation were a deteriorating political crisis, violence, and a staggering increase in human rights abuses. In addition to the conditions that led to the TPS designation, Haiti has experienced the assassination of its president, an earthquake, and a tropical depression. Due to these concerns, the head of Haiti's National Migration Office requested a humanitarian moratorium on the expulsion of Haitians from the United States. Now, this concern is just the latest in numerous concerns for all of the migrant populations that have been expelled, particularly from our southern border, with enormous concerns about chain refoulement for Central American migrants and dangers of death and kidnapping that happen to migrants who are expelled to southern Mexico. So I want to start with grounding this in the broader context of international law. And I'm going to start by asking Professor Ona Hathaway to start by outlining what are states' obligations under international law during COVID-19 pandemic, and tell us a little bit more about the obligations to migrants and asylum seekers that reach our territory or are within our effective control.
Yeah, great. Thank you so much for the invitation to join you all today. It's great to be part of this conversation. As Melissa rightly noted, my remarks are going to draw from a forthcoming article on COVID-19 and international law that's been posted on SSRN and will be coming out shortly. So if anyone wants more details, I encourage you to look there. So let me start with so there's a whole host of international law obligations, and I won't go into the broader set. I'm going to focus here on non-refoulement obligations, and whether there are exceptions to them that apply in the context of a pandemic. And then I'll say a few words about obligations that apply to states that are holding refugees, asylum seekers in detention, and what kinds of obligations they might have. So first on non-refoulement obligations. So this principle, which our listeners may be familiar with, but in case not, prohibits states from engaging in conduct leading to the return in any manner whatsoever to an unsafe foreign territory, including rejection at the frontier and non-admission to the territory. That's a principle that's enshrined in the 1951 Convention relating to the status of refugees and its 1967 protocol. And it makes clear that, therefore, that asylum seekers should not be returned if they will meet threats on account of their race, religion, nationality, membership of a particular social group or political opinion. There's also a non-refoulement obligation separate from the obligation established in the Refugee Convention and its protocol that apply under various human rights conventions. So, for example, the Convention Against Torture states that no state party shall expel, return, or extradite a person to another state where there are substantial grounds for believing that he would be in danger of being subjected to torture. And the Human Rights Committee has also found that under the International Convention on Civil and Political Rights, there is also a principle of non-refoulement. The ICCPR affirms that no one shall be subject to torture or cruel, inhuman, or degrading treatment or punishment. And that principle of non-refoulement is understood as being read into and a part of the ICCPR convention. So there's a number of conventions, both human rights conventions and then refugee-specific conventions that prohibit refoulement. Now, the key question is, what are the exceptions in case of a pandemic? Are there exceptions? Are there limits to this in the case where there's a public health emergency? So a number of states have certainly laid claim to a right to restrict admission due to the pandemic. In April 2020, so this is a while ago, the UNHCR found that 167 countries had fully or partially closed their borders to contain the spread of the virus. and 57 of those countries had made no exception for people who are seeking asylum. So effectively just closed their borders regardless of whether someone in fact had a valid claim to seeking asylum. In the United States, the CDC issued an order in March 2020 that effectively suspended asylum processing, and I'm sure many of my co-panelists are going to say more about that, for persons traveling from Canada or Mexico. And many experts worried that that was overbroad. Now, while it is the case that governments can take certain protective measures in response to COVID-19 under international law, they are not entitled to completely prevent the entry of asylum seekers. So under Article 33.2 of the Refugee Convention, it articulates an exception to the prohibition on refoulement. It says the present provision may not be claimed by a refugee whom there are reasonable grounds for regarding as a danger to the security of the country in which he or she is seeking admission. But reliance on that exception, it's been found, requires individualized showing. So it requires an individualized showing. It cannot be applied on a blanket basis to everyone seeking asylum, regardless of whether they actually pose a threat. So a host state must make an individualized determination that a person poses a danger. And moreover, even if the person has COVID, it's not necessarily the case that they could be expelled or returned. They may be subject to, health protocols, temporary holding while during the period that they're contagious. But it's not clear that that it necessarily permits their even a person who is contagious their immediate return. And particularly, even though there is this exception in the Refugee Convention, there's no derogation to the non-refoulement obligation under several of the other human rights conventions. So the Convention Against Torture, their prohibition on non-refoulement is non-derogable, meaning that even if a person might be thought to have a communicable disease, they can't be returned to a country where there's reason to believe that they're likely to be subject to torture upon their return, for instance. And a similar limitation likely applies as well to the ICCPR's prohibition on non-refoulement. So the idea, in other words, that under international law, sort of all bets are off during a pandemic is clearly not true. And a number of states have effectively treated it that way, rather than doing what they really should be doing, which is making an individualized determination and then providing other mechanisms for assessing whether someone is assessing their claims and providing alternative ways to address whatever potential health threat there might be. Now there's a separate question, and I'll try to keep this quick because I want to make sure we have time for all of our speakers. You've asked me also to address the question of obligations to migrants and asylum seekers in detention. And there's a whole host of obligations that apply to countries that are detaining people, asylum seekers, refugees, and other migrants. And migrants arriving in foreign territory in large-scale influxes and residing in camps or settlements often face really dangerous conditions that elevate the risk of infectious transmission. Often resources for sanitation, clean water, soap, personal protective gear, et cetera, is not generally available to people in these situations. Then there's plenty of evidence that people have been held in pretty dangerous conditions where the risk of COVID transmission has been high. And this is not just true of some of the places that we read about in the papers outside the United States, but the United States itself has been accused. And there's been evidence, and again, I think my co-panelists will speak to this, of people being moved around from crowded facility to facility, regardless of their COVID status, and being potentially exposed to COVID in detention as a result. And that is deeply troubling and likely in violation of obligations under various human rights, both under the Refugee Convention, but also under various human rights conventions, the ICCPR, and that's the International Convention on Civil and Political Rights, the Convention Against Torture, and the International Covenant on Economic, Social, and Cultural Rights, in particular, established very significant international human rights obligations on states to ensure the right of everyone to the enjoyment of the highest attainable standard of physical and mental health. That's the language from the Covenant on Economic, Social, and Cultural Rights, course, that applies only to states that are party to that convention, which doesn't include the United States. But several of those obligations also apply to states that are party to the International Covenant on Civil and Political Rights, which establishes, for instance, a right to life, which likely entails certain kinds of protections against intentional or knowing exposure to COVID-19. So the UNHCR has compiled an extensive toolkit that outlines a number of treaty obligations that states, parties to various human rights obligations have towards detainees during the COVID-19 pandemic, that lays out some of this in some detail. And that includes providing migrants with free and non-discriminatory access to healthcare services that have the same standard of care as those available in the community, ensuring ventilation, cleanliness, disinfection, waste collection, providing free masks, free gloves, other supplies, this kind of thing to reduce the likelihood of transmission during times of detention, and then providing care for those who do contract the disease. So with that, I will pause, but I look forward to the conversation.
Thank you so much for those really enlightening comments. And I'm going to go next to Dr. Louise Ivers and to talk more about the public health justification that has been given for this order. As you know, the CDC has claimed that this order is necessary to protect the public health from the danger of the introduction of COVID-19, to mitigate the risk of transmission, and to mitigate the risk of further strain on the already strained U.S. healthcare system. And I'm wondering if you could just give some thoughts on what is your assessment of that claim, of its necessity to protect public health, and then maybe give some comments as well. Ona just mentioned that obviously there are obligations not to send people back to their country where they have a well-founded fear of persecution or torture, but there can be some limitations on the introduction of even asylum seekers and people who are found to be refugees under our various convention standards. So what would be some reasonable public health measures that could be taken in order to protect the public health? Thanks, Louise.
Yeah, thanks very much. And thank you for inviting me to be part of this very distinguished panel. I just have a couple of comments. First, I'll just start with the fact there is absolutely no medical or public health rationale for this measure. That's not just my opinion as an infectious diseases doctor or public health expert. Many medical experts, public health experts have said the same. You can see this in many public letters that have been written over the last 18 months. And you mentioned yourself that Anne Schuchat, who was Principal Deputy Director of CDC for a very long time, herself said last week that even at the time, it was not based on any public health assessment. So even if we were to imagine that back in March of 2020, there was so much unknown about this virus that there was a stop first and ask later scenario, what's very clear now that at the end of 2021, we know so much more about how to control, prevent, even treat this disease, that there's definitely no rationale at this stage. We have measures such as testing. We have measures such as treatment emerging. We have quarantine, which we know can be effective. We have vaccinations, which are really the most effective way to prevent transmission. And we know that masking and other measures can also dramatically reduce transmission. So there's just no medical or public health reason for this. Also, I think what's really important to remember is that this measure is xenophobic and adds to a sense that is very present in the history of public health of describing others as vectors of disease, as harbingers of disease, in a way that's very detrimental to their own health, to their own process, and to our society, and is something we really have to pay attention to. For many countries, and Haiti is one, I'll come back to it, the COVID incidence rate has actually been lower than it was in the US, and much more preeminence needed to be paid to the control of COVID within the US's borders, and the transfer of people across the border was much less of a risk. The impact here on asylum seekers and migrants, I think, is disproportionate. Millions of, almost 100 million people have passed the US border from other countries during the time of this measure being in place. And that has not been the most important part of our disease control. So I think it's important to think about how we are disproportionately affecting asylum seekers and migrants. And then I'd like to say a word about Haiti in particular. I was in Haiti in late August, just after the earthquake, and I noted that on August 23rd, the US government had posted a level 4 travel warning, which could make sense from some, I mean, that's debatable from some issues that are happening in Haiti, but they included in that a high risk of COVID-19, which is actually nonsensical, because at that time, there were just a couple of dozen cases of COVID being reported every day in Haiti. Now, everyone would agree that there's not as much testing in Haiti as everyone would like. However, even with that, taking that factor in mind, it just made absolutely no sense to call Haiti a level 4, have a level 4 alert from a COVID-19 perspective. So I think what happens from my point of view here is that when public health measures are weaponized or are used as political devices, I mean, public health has politics involved always, we know that. But when measures are used as devices for politics, it really actually undermines public health. And it makes people wonder, what is public health about and what are we trying to do when we really have measures that are critical to control diseases? So I have many concerns about the use of Title 42, and those are just a few, and I look forward to the discussion and any questions or comments that come from this. Thanks.
Thank you so much, Louise. And I'm going to go now to Gerline Joseph. Gerline, you've been working so closely with migrant communities at the southern border, in particular Haitian migrants. And so I'd love to hear, what are some of your concerns that you have for the migrants who are being impacted by this policy and return to either their country of last transit or their country of origin?
Thank you so much, Melissa, for having me with all these amazing, phenomenal panelists. And I just want to start from where Louise left off, as far as how the use of Title 42 has been impacting migrants at the US-Mexico border. And then we can just take a look at that through the lens of the Haitian quote-unquote crisis, where the world finally saw what was happening with migrants and saw what was happening under the bridge in Del Rio. And people are thinking this is something new. And we are telling them that the Haitian Bridge Alliance actually started the fight against Title 42 in April of 2020, when we sent the first letter to then President Trump, asking him to stop deportation by using the new CDC Title 42 that they were starting to implement because Haitians were being deported during that time. And I remember the first deportation that actually we were flagged having about 4 people who were tested positive for COVID-19. It was April 7 of 2020. And as was mentioned at the time, they also had a level 4, do not travel to Haiti due to COVID-19. And we clearly understood how the United States willingly was exporting COVID-19 to Haiti, a country that had only 129 beds that were equipped for COVID-19. So that was the first flag that we had as far as how they are using Title 42 to completely close the border, thus putting lives at risk. And we see that we continue to ask, if Title 42, as they say, is to be used in that matter, are you testing migrants? Are you testing the Haitians that were under the bridge that have been forced to stay in Tapachula, in Tijuana, across the US-Mexico border for the past year and a half? Are they being tested? And now if they are being tested, therefore, if they're tested negative, they do not they are not a risk to bring COVID-19 into the country. So therefore, they should be allowed to continue the process. If they are not, if they test positive, we have the means to quarantine them, right? And make sure that they are protected and safe. And once they start testing negative, allow them to continue the process so they can get protection. But if we say we are just deporting people due to COVID-19, while right now we are on a big campaign asking everyone to get vaccinated. And now not only we have the 2 doses, we have the booster. There's absolutely no reason why people should be continued to deny access to protection under the rules of Title 42, which we knew from the beginning did not hold water. So we talked to the people on the ground, as you know, and we've been serving them and trying to see what's the best way to address Title 42, and also asking the administration, starting with the president, the vice president, the secretary, Mayorkas, you know, Susan Rice. Unfortunately, we read on an article, you know, how they are using, you know, COVID and Title 42 to not allow people who are detained to get the support, to get vaccines that they need. Which is outrageous. As a country, we cannot continue to be the same cruel system that have been enacted simply to prevent people from getting asylum, from getting protection. And what we say is that when it comes to Haiti specifically, we see, as you mentioned earlier, Melissa, after the previous to the assassination, we had the kidnappings and the violence and the murder of young women and women activists on the ground. And then we had the assassination of the president. Literally 3 weeks later, they started deportation again. And on the eve of the earthquake, they had a deportation. And we've been asking them to stop deportations, but they have been unable to commit to protecting people instead of literally putting them at risk. And we see they are using this Title 42 to expel people, women. We have reports of women who have given birth in the United States, in Texas, who were detained in Texas, then they were deported with the child. And we also have report of extreme mental health problems with people who have been deported after making this journey, being forced to stay in Mexico for that long, and finally being able to present themselves to ask for asylum, be treated as less than human, that we all saw, to be put in detention without access to any hygienes, and then be deported in handcuffs. And last night, I received a report of a woman who was deported with a baby, and the way she described how they treated them, as she was holding the baby with handcuffs, the baby fell and rolled under the seat of the plane, and still they did not treat them with kindness. They still wanted to treat them as less than human. So while we look at how they are being returning people to Haiti as a result of Title 42, actually I think under the guise of Title 42, we are asking for them to immediately stop using Title 42, especially now that we have the vaccines, we have the booster, we have quarantine options, and we just opened the US-Mexico border for non-essential travelers. So if non-essential travelers can freely enter into the United States, what is preventing those asylum seekers, people who are in need of protection, from getting the same access, from getting access to actually present their case and get access to protection to be able to continue their cases in the United States? I am looking at the time. I'm going to stop here because I know you will go inside many of those issues that we have been dealing with for a very long time. Thank you so much.
Thank you so much, Marlene, for sharing some of those details, and particularly the troubling details of how migrants are treated when they are expelled from our southern border. And I think this is a systemic issue that impacts migrants whether or not they have protection concerns or not. It's a separate human rights concern about how we are treating people who are expelled. But it's heightened when we talk about some of the obligations that Ona outlined, are obligations under our international conventions that have been implemented into domestic law about making sure that anybody who has a protection concern has an opportunity to raise those concerns before they are expelled from our borders. And even though there is some tension with protecting public health, that there are other methods that we can take, as Dr. Ivers outlined, to be sure to protect the health of asylum seekers as well as the public health of United States citizens. So I think for those of us who are troubled by the implementation of this policy, we want to know, so what's being done to stop this policy? And I'm so pleased that Lee Gillern can talk to us about the efforts of the ACLU along with partner organizations to file lawsuits in federal court to challenge the implementation of this policy. And I'd love for you to talk to us about the status of this lawsuit, when it was filed, what's the current status, and any efforts that you've taken maybe behind the scenes to negotiate with both the Trump and Biden administrations to stop the use of this policy to expel migrants from our southern border. I think you're muted, Lee.
Sorry. Thanks so much for having me. This is a great panel. I look forward to the questions. Let me just give you one short answer and then give you background. The short answer of negotiations with the Trump administration was there were zero negotiations, zero interest, as I'm sure people can imagine. We filed these lawsuits. We filed 2 lawsuits during the Trump administration. One was for unaccompanied children. The other was for families, saying that the use of Title 42 for both groups was illegal. We also believe it's illegal for single adults. These are the 2 lawsuits that we have filed thus far. We believed from the very beginning that the Trump administration was using Title 42 as a pretext to do what it always wanted to do, which is stop asylum at the southern border, particularly for people of color. And so we filed these lawsuits. We got an injunction for the children's case, a national injunction. The government appealed. There was a stay of that decision, and briefing was continuing. The Biden administration came in and said, we'll exempt unaccompanied children. On the family lawsuit, the lawsuit was proceeding when the Biden administration came in and said, hey, will you guys talk to us without proceeding with the lawsuit for a moment? And we think that the Trump administration depleted our capacity at the border to do asylum. Talk to us, let's negotiate. We negotiated for 6 months. We got many people in through an exemption process, but that was no substitute for an actual asylum process. Ultimately, the Biden administration chose not to get rid of Title 42. That's still their position. So we went back to court. We got a national injunction prohibiting the use of Title 42 for families. We had hoped that the Biden administration would not appeal that decision. I got a call. We got the decision that afternoon. Before midnight, I got a call from the Biden administration saying we're appealing immediately. They appealed, and they also asked for an immediate stay. Unfortunately, the DC Circuit has stayed the injunction, meaning that they can continue to use Title 42 for families. They expedited the appeal, and so we are in the middle of briefing that appeal, and there will be argument in the DC Circuit Court of Appeals on January 19th about the legality of Title 42 for families. And what we have argued is 2 basic points. One is that Title 42 does not authorize expulsions at all, putting aside the protections for asylum seekers and withholding the non-refoulement protections. It doesn't authorize it at all. And what we've pointed out is that when it was originally enacted in 1893 and not changed since then materially, it was only supposed to regulate ships, meaning ships coming from Europe with cholera. That's what triggered the law. It was never meant to actually regulate individual travelers, just transportation entities. and certainly even if it allowed for the regulation of individual travelers, doesn't authorize expulsion. We've also argued that even if it allowed expulsion of individual travelers, it has to be read in conjunction with all of the asylum laws, broadly speaking, and that those asylum laws later enacted and more specific to protection take precedence, and that those asylum laws have been, over the past 40 years, continuously amended. Exemptions have been put in, particularly for those with criminal convictions, but never once has Congress said there is an exception for people with communicable diseases. Congress has looked at communicable diseases, said that could be a ground for expulsion, it could be a ground to block entry, but not where asylum seekers, right? That you can have quarantines, other types of health restrictions, but you cannot deny access to an asylum hearing or a screening. We'll see how that plays out, but it's basically a statutory question. Is there authority to do this? I think one of the difficulties for us has been trying to really bring home the harm that is at play here. It's hard to break through the noise, as Gerlene talked about and Louise talked about. There is serious harm, but once in a while it breaks through. The Haitians under the Del Rio Bridge broke through. What we have tried to show and put in evidence to show is that not just the Haitians, but lots of people are suffering real harm. In some places on the border, 20 to 40% of the families are being kidnapped. And it's a direct cause with Title 42, right? The families are literally being pushed over the bridge by the United States government. The cartels know what times the expulsions occur and wait at the other end of the bridge to kidnap them and brutalize the families. And so we know this, the United States government knows it, that when they push the family across the bridge, there's a high probability that they will be kidnapped, held for ransom, and other things, and yet we're still doing it. So I think one of the things that we have been trying to do is get that out into the public, just how brutal this is, and also obviously to show that it's not a public health, there's no public health justification. We felt that from the very beginning. Now, as other panelists have said, there's absolutely no basis for saying we can't do this safely. And the only other thing I want to say, because I think this is absolutely critical, is you do not need to actually disagree with the CDC to find that there's no public health justification. I think the Biden administration has unfortunately taken cover under the CDC, but what I think very few people are doing is reading the CDC order carefully. The CDC order does not say we cannot safely process asylum seekers. What it says very clearly is there are mitigation steps that can be taken so that we can safely process asylum seekers, but DHS, Department of Homeland Security, has not taken those steps. So what public health officials who have read the CDC's latest order and have put in affidavits in our case have said is that this is an indictment of DHS. It is not a conclusion by medical health experts that we cannot do this. It is very clearly telling DHS, this is on you. The Biden administration wants to act as if CDC is telling them we just can't do this, but CDC is not saying, and I think that's critical for us in court and generally for the public, because people do not want to disagree with this administration, CDC generally, but I don't think they have to in order to conclude that there's no public health justification. So I'll stop there and hopefully we can discuss that more.
Yeah, thank you for bringing up that important point that it's, I think, in large part due to the failure of DHS to implement some of the changes that could be undertaken in order to undertake these mitigation measures. And thank you as well for sharing some of those statistics on kidnappings. I was particularly struck in reading some of the affidavits in the case about some of these incredibly high statistics. So the number of people who are kidnapped or subject to attempted kidnapping, and the stories of sexual gender-based violence against migrants who are returned. And Gerlene, you've been given a platform in large part because of the attention that's recently been placed on some of the high profile actions that have taken against Haitian migrants. I know you have to leave before the end of the hour. So I'm wondering if you might just share, are there any, as an activist, are there any advocacy steps that people can take to join you and some of the partner organizations who are advocating on behalf of migrants at the southern border? And you're muted as well. Great.
Thank you so much. And before I answer that question, I want to let Lee, Louise, and Ona know how grateful I am for each and every one of you, really, to be able to bring the realities of what Title 42 is and how it affects people at the US-Mexico border, and looking through the lens of Haiti specifically. Right now we are, for me, I tell people I am tired, I'm exhausted. This has been happening since 2015 for me. I started under President Obama or President Trump, and now Biden. I am exhausted and I'm tired. And I am ready to do whatever needs to be done to end Title 42. So we are launching, to me, what is going to be the last phase of the campaign to stop Title 42 and to stop deportation, to provide protection for people at the US-Mexico border. And what we always say with the Haitian Bridge Alliance, we went for the Haitians, but we stayed for everyone. Our fight is not only to make sure that the Haitians are protected, giving the specific issues that Haiti is dealing with, as we see. What I always say is that Haiti is like a burning house. It's in flames, and the United States, instead of providing safety, sending in the firefighters to save the people, but they are literally dropping pregnant women, little babies, children into the burning house. So that is unacceptable. And so I am ready to end Title 42 as soon as possible. So we are calling on our colleagues. We are calling on everyone in the United States who can stand for justice and freedom and liberation, who wants to be able to say, yes, this Build Back Better that the president is talking about, we cannot build back from what we are witnessing. The Saving the Soul of America that he ran his campaign on, we cannot save the soul of America while we are witnessing what is happening, how we are literally destroying souls under the bridge and talking about saving the soul of America. So my call is for everyone to join us in this fight for protection for people. And we are asking for President Biden to end Title 42. As you just heard, there is absolutely no reason for it. There were no reason for it before, and there's definitely no reason for it now. We will be releasing another letter asking everyone to sign on, make the call to Congress, asking them to push the president to end Title 42 and stop deportations. So as I mentioned, I am ready to make sure and to see that the administration finally admit that no, Title 42 does not hold water, and there's no medical, no health reason as to why we started in the beginning, and we are ready to end it and provide a safe way for people to get asylum. One thing I want to mention is when it comes specifically with Black migrants, for Black bodies in motion, there's no safe space for us. Throughout South and Central America, we hear the reports of women being raped, children, outrageous, really. And what I tell people for Black migrants in Mexico, we cannot blend in. The moment we step foot into a space, our very presence makes us more vulnerable than most. So for the United States to continue the use of Title 42 to literally destroy the lives of those people, to literally look into immigration, not just the issue at the border, it is a Black issue. It's a racial justice issue. is a woman issue, is preventing child sexual abuse and preventing kidnapping issue. And we see that the United States has provided the perfect conditions for trafficking and coyotes and all of those people to flourish at the US-Mexico border. So enough is enough. My call to action is that we must provide protection by ending Title 42 and provide access to asylum for those who are in need.
Thank you so much, Carlene, for those comments and for joining us today. I want to turn back to you, Ona, and this question of international law. One of the things that I was struck by in reading your latest piece is some of the challenges in implementing some of these obligations, and particularly for refugee law. I was listening to comments recently by James Hathaway about how the Refugee Convention is one of the few human rights conventions that doesn't have an enforcement mechanism. And one of the things that you've written about extensively is this idea of outcasting as a way to develop enforcement mechanisms in international law. And in your latest piece, you talked about maybe embedding and incorporating this into a revision of the international health regulations. And I was wondering, in your other piece, you talked about potentially embedding one regime within another, and whether there might be some opportunity to embed some enforcement mechanisms for protecting the rights of migrants within any potential revisions to international health regulations, since there is such a pressing need there and lack of desire among states to revisit any of our obligations under the Refugee Convention, and where some of your ideas around outcasting might fit into these challenging enforcement questions.
Yeah, thank you for that great question. I mean, this is just a perennial problem that we face in the context of human rights writ large, is that human rights conventions impose a great deal of obligations on states, but even those that have committees that oversee their implementation often don't have very stringent enforcement mechanisms attached to them. There are some exceptions. The European Convention on Human Rights has the European Court on Human Rights, where cases, complaints can be filed and decisions can be rendered that states have to abide by. But that really works primarily for two reasons. The key one being that it is embedded within a broader political and economic framework, so that in order for a state to be a party to the European Convention, to the European Commission, you have to be part of the European Convention on Human Rights, which also entails mandatory jurisdiction before the European Court of Human Rights. So it's sort of a gateway requirement for entry into a whole host of political and economic benefits, and that helps hold states into a system that has a strong enforcement mechanism. Most international human rights treaties, and the Refugee Convention included, don't have anything like that. And so the main way in which these conventions are enforced is twofold. One is occasionally there are efforts to what we call in the outcasting piece cross-countermeasures. So where a human rights obligation is connected to access to some other benefit, or might be met with some other kind of penalty, like, for instance, economic sanction for a violation of human rights. But the best way to do it is to embed it, as you've suggested, kind of embed it into a broader system. And it's also the case that the more that we can find ways to enforce this through domestic courts, the better. So the work that Lee is doing is really key, that many human rights treaties, the main way in which they are enforced is through domestic courts, not through some kind of international court system. It's through having access to the courts domestically. The difficulty in the United States is most human rights treaties are not what we call self-executing, and therefore you don't have a cause of action that you can actually bring in court. So you have a violation of the International Convention on Civil and Political Rights or the Convention Against Torture, for instance. Those are not self-executing. You have to find some statutory obligation that's been created to implement it, and if that doesn't exist, then you're kind of out of luck. So I think we have to always be thinking capaciously and thinking about human rights, law. How do we build it into our systems, and how do we think not just about creating new obligations, but creating new obligations that will stick and be effective? I do think the work that some of us do to try and bring attention to these matters, naming and shaming, is a piece of that. But thinking about whether there are ways to embed these obligations into other kinds of political and economic systems, international systems that give states benefits that they want access to, is one way to think about enforcement. Because if you create an international system that's all costs and no benefits, it's very hard to get states to be a party to that. So I think as we're, not just limited to this area, but generally speaking in human rights, we need to be thinking in this next generation of kind of human rights, international law enforcement. We need to be thinking about those kinds of tools and how to make these promises a reality.
Thank you so much for that thoughtful answer. I have another question that's both for Louise and Ona. One of the concerns that I think people have is for not just the impact on the migrants who are being returned and their own sense of health, but also the public health implications in the countries in which they're being returned. And so, Louise, I'm wondering if you can talk a little bit about the ability of healthcare systems in countries like Haiti to absorb large numbers of migrants who are expelled that may or may not be COVID positive, that may or may not have other health challenges, and how they're able to deal with that influx. And then Ona, maybe address what are our extraterritorial obligations to these other states and the human rights of people living in other states and their right to health. So Louise, why don't you maybe speak first and then hand off to Ona?
Yeah, I mean, I think Lee and also Gerline touched on the challenges for those who are, not allowed to enter the US. I mean, I think if you think about actually just the overcrowding and the physical and psychological harm that is done to people at these border camps. And my colleagues here at Mass General have been working over the last 2 years to provide medical care on the Mexico side of the US border, and have really described and echoed the testimony that Gerline has described of how people are treated and how they're living. I think there are many concerns about sending people to very crowded conditions. They are about COVID-19, but they are also about influenza and measles and other types of potential infectious diseases outbreaks. I know Physicians for Human Rights did a study recently where they had 96% of the people they interviewed were describing mental health conditions, those who were on the other side of the US border in Mexico. If we speak specifically about Haiti, I mean, Haiti, frankly, just does not have the healthcare system capacity to be able to deal with a large outbreak of COVID-19. The health system has been relatively spared. I'd say if we were to compare the COVID-19 pandemic in Haiti to the US, the degree of illness and suffering has been less for a variety of reasons. However, even that has really strained, and you see health hospitals being unable to accept new patients, running out of medical oxygen. At the moment, there is a substantial crisis on fuel. And so a number of hospitals have actually been closed because they can't run generators. So I think on all levels of public health, even just speaking about COVID-19, there's certainly not capacity there to manage. But even on a ordinary pre-pandemic day, I mean, there are many chronic illnesses, acute illnesses that are really, the Haitian health system just doesn't have the infrastructure to be able to support. There's fantastic healthcare workers there, but they don't have the tools that they need to be able to execute on what they often really know that they want to try to do.
Yeah, and as to your question about sort of what are the international human rights obligations, in the article we try to walk through for each of the rights that we identify. We try to walk through, which of these apply extraterritorially, and kind of where are we reasonably certain that they apply extraterritorially, and where they're sort of more questionable, or there's kind of more of a debate about the extraterritorial application of the rights. As I'm sure you know, the US takes a very kind of crimped view of the extraterritorial application of its human rights obligations, and it generally views ICCPR as not applying extraterritorially, even though most of the rest of the world thinks that it does, at least to instances where a state exercises effective control over activities abroad. And it has, in the last time the US reported before the Committee on Torture, it accepted some modest extraterritorial obligations under the CAT, but only applying to Guantanamo and US ships, and not extending more broadly than that. And so this is a kind of a point of contention, generally speaking, not just in this particular context, about the extraterritorial obligations of states for the human rights harms that they cause abroad. The case law on the International Covenant on Economic, Social, and Cultural Rights seems to be broader in terms of the extraterritorial obligations that it imposes, but those, of course, apply only to states parties. Focusing on the U.S. for the moment, that doesn't apply to the United States because it's not a party. I do think that one thing that the pandemic has shown us is that while there are extraterritorial obligations that do apply, and we try to lay out some of those, it remains a pretty big blind spot in the law, frankly, and particularly when you're dealing with a communicable disease and where you bring people, you put them in a crowded detention facility where COVID is rampant. They catch COVID, maybe they didn't arrive with it, but they get it, and then you send them back home. You're really exacerbating a global pandemic problem. You're part of the problem. And we haven't really, I think, thought carefully enough about those obligations, and to what extent do states, should states accept more stringent obligations on their behavior when it comes to these kinds of health crises, not to exacerbate the situation. And I'd say that right now, while I can make a strong argument, and we try to, that there are instances where there are extraterritorial obligations, I will say that there remains something of a gray space and certainly a contested area, and one in which I think it would be fruitful for there to be more development of the law.
I think that's right. And speaking of more development of the law, Lee, I'm wondering, this comes a little bit from our Q&A, but I'm wondering if you can talk about the extent to which you're even able to incorporate some of these arguments about the US's interpretation of our obligations under international law, and it's being somewhat interpreted more narrowly than maybe UNHCR would interpret, or the Human Rights Committee, and if you incorporate that at all, or if you really have to focus on our domestic laws and how they should be implemented.
Yeah, thanks for that question. It's not that easy, this is a short answer. What I think we're doing is a few things. One is we always make clear that our domestic laws are based on our commitments under international law. But ultimately, I think, as most people know, the US courts want to look to domestic law. But I think it does help to point out what international law requires. And so in that sense, UNHCR weighing in has been very important. But the other aspect of it, which we haven't really touched on that much, is comparative law, right? And I think Ona has mentioned that what other countries are doing. I think there's probably a sense that if every other country is not making an exception for asylum, then the US is not really doing something so egregious, but not really an outlier. But what we've tried to point out is that most countries that we look to for human rights issues are actually making an exception for asylum, even if they're generally closing their border. And I think that's been important for us. But I don't anticipate necessarily, an opinion that says it's grounded solely or specifically on international law. The better, I think, courts do talk about how our domestic laws pattern on international law and was based on our commitment under those international treaties. But we'll see. I think this is an area where, domestic civil rights lawyers need to do a better job of incorporating international law, but it's tricky.
Well, I really appreciate that thoughtful answer. And unfortunately, I think we're out of time. I could continue this conversation for many more hours with all of you, but I just want to thank you again for giving of your time for this really insightful and important conversation about Title 42 in international law. Thank you, Dr. Louise Ivers and Professor Ona Hathaway, Lee Gallant, and Perlene Joseph for joining us today. And thank you again for the American Society of International Law for creating this space for this conversation. Thanks for joining us.